It's always a pleasure to be here. Been a member of CCDL for a long time, and an honor to do so. As some of you may have heard, the ATF and the state police had a workshop for our federal firearms licensees, FFLs, last Wednesday. We had a very good turnout from our FFL community. We were in the auditorium at the Connecticut State Police Training Academy, and they had no microphone for any of the speakers. So here we have a room with hundreds of gun owners who all have superb hearing, maybe not, and not a microphone to be seen. Apart from that, I think I applaud the state and I applaud the ATF for the fact that they did it. I think we need to do more of this. I think the real key is to get the communications out there so that we have people who are trying to comply with the law who are able to do so because we have a free exchange of information. So this is a step in the right direction. My concern was this. Given the lack of microphones, audio, I think there's many people in the room who did not hear what was said. And number two, it was only the FFLs. Unfortunately, this is impacting everyone. And one of the best ways I think that we can start to get this information out is through organizations like CCDL. So you guys, hey, I'm counting on all of you. I'm just the messenger here. Some of you know me. I've practiced law now for 34 years, most of it involved with firearms compliance. I'm counsel for a defense contractor. So we kind of work with these laws all day long. Having said that, there are questions here that we still can't answer. Back in 1993, my firm, along with Wes Horton's firm, we came in, we challenged the original assault weapons ban in Benjamin versus Bailey. We gave it a great shot. We put on a great case. Unfortunately, under technicalities on the civil standards, the law stood. The law was vague then. It's vague now. And there's going to be things we can't answer. The problem here is that over the 20 years or so since the original law, the state police have reached out to the FFLs and reached out to the communities and through their websites, and they've given us an interpretation of what they think the law means. Didn't mean they were right, but at least we had something we could work with. And that kind of culminated in 2013 when an attorney in Connecticut named Dave Clough came in, and he wrote to them and asked a question, and he got a written opinion back. People relied on it. Now it appears they've changed their position. So with that intro, let me kind of start into the presentation here. Okay. So once again, what we're going to go over tonight is some of the things that were said last Wednesday. And to people who may find themselves involuntarily pulled into this criminal justice system, we're going to talk about some of the things that we do have available, some of the responses that we have. And I have no doubt the response I'm going to get from many of you tonight is, you must be kidding. But I'm not, unfortunately. All right, let's go to the next slide here. One more thing, we have a lot of material to cover, so I'm just going to ask that people hold their questions till the end. We'll have the panel here. We're fortunate tonight to have Andrew Buzzi, who has worked with me on these types of cases over decades. Doug Dubitsky, our state representative, and Craig Fishbein, our representatives, both longtime members of the bar. So I don't know we'll be able to answer everything, but we're going to try and shed a little bit of light here to kind of point out some areas that are creating problems and hopefully avoid them. Let's go over here on a history of the bans, just real quickly. We get back to 1993, CGS 53-202A, and the challenge to it, Benjamin versus Bailey. It's up there, it's posted, you can read it. We went through, but at the core of Benjamin versus Bailey, we came in under the Fifth Amendment due process. And What due process requires is that any criminal law be stated with sufficient specificity that a person of common intelligence can understand what is prohibited. Unfortunately, I don't think the court understood what was prohibited, and because they didn't understand it, I don't think they understood even what the problem was. And that's a bit of a challenge. How that happens? They deferred to the legislature. The legislature, well, we're not sure what it means. The legislature must have known because they passed the law. That's what they did. Okay. So let's come on over here to the 2018 workshop. Let's go over to the next slide here. One more slide. Okay. So let's come on in here into the, let's see, do we hop over one here? We're, all right, we'll come back. We'll come through here. We're a little out of order here, but the 1993 specified list. One of the questions that's creating the most problems today is what we refer to as pre-bans. These are firearms which in 1993 and 94, when the law came in, were not required to be registered. That remains the law in Connecticut. If you did not have to register it in 1994, it doesn't have to be registered now. It's not an assault weapon. It's simply a long gun like any other. The question then becomes, a list of 56 guns, what are they? It seems like it should be a really easy question here. Unfortunately, when we look at variations on models, sometimes the exact model is written on the side of the firearm. Sometimes it's not. And we presented this in 93 to Judge Dranginis up in Litchfield at the trial court, and Judge Dranginis said, well, just look at the firearm. It is whatever it says on the side. That's kind of still where we're coming from today. And you have to take a look at this. But then they came in a moment of unfathomability, they added in all of these guns which they called types. What is a type? And we went to the court and we said, we don't know what a type is. And the trial court came back and said, well, we don't know what it is either. But if you want to buy a gun and you're not sure whether or not it's one of these types, you should just go ask your dealer. Yeah, that sounds like good law. And the Supreme Court looked at it, and they didn't really agree with that. So they came in and they said, well, we don't think you can just ask the dealer. The dealer said it was okay, it's legal, it's legal. So instead they said, well, you should look at the manufacturer's catalog. If you can find a catalog for something made in 1943, you're a better man than I. It just didn't work. And catalogs don't work that way because catalogs aren't written the way the statute was. So it was foolish then. It's foolish now. But one of the things that, especially for any of you in the room that are in FFL, you've got to have a copy of this specified list. And it is the 1993 list. The way the Act is written is so complex, it took me 4.5 hours to figure out which list it was. But if you go back and you go through and you read through and you look at the effective dates, this is the list. It is up there. My cards are here. If anybody needs a copy, I'm glad to send them out. All right, let's go to the next slide here. Okay. Okay. National Firearms Act guns. I hear this all the time. Somebody goes out and they build a short-barreled rifle. Now, we typically in the industry refer to those as SBRs. And when you want an SBR, what you have to do is you have to file federal paperwork, what we refer to as a Form 4. It's a $200 tax stamp. It takes the better part of a year. You go through the procedure. And it comes back, and good, I've got federal paperwork. I'm clear. Well, maybe yes, maybe no. The state police position on it is, if it is something that is specified in the act, or it's made after the date of the act, the key date here being October 13th of 1994, and it meets the characteristics, we don't care you have federal paperwork. It's still an assault weapon. So a lot of confusion there. We need to be careful about that one. Okay. We have the Kaminsky case, and we're going to talk a little bit about that. The Kaminsky case is up on appeal. So we have a state police position on it. We have issues that are up on appeal in Kaminsky. We're going to have to wait and see. But for right now, if you have a gun that is on this specified list, or it's made after October 13th of 1994, and it meets the current characteristics test, if it's not registered as an assault weapon, you're looking at 3 years mandatory. Let's go to the next one here. Okay. All right. When we talk about these SBRs, it's relatively common right now to build them with 10-inch barrels. It's a configuration that is commonly used in law enforcement. We commonly see it in the civilian side. Okay. Let's assume here that we have something, and we look at it, and we say, well, it's not really an assault weapon. It's not a rifle, pistol, or shotgun. And some of you will know what that means out there, things we refer to as other. But Connecticut law, the definition of a pistol, says a pistol is a firearm with a barrel under 12 inches. So you build a 10-inch barrel SBR, or you build it as a so-called other, it is a pistol. And you have to watch that interaction there with the Connecticut law as we get into the issue of, is it an assault weapon or is it not? Now let's go over. All right. One of the very common problems we're seeing right now, clients are calling up and they're saying, I bought a firearm from my local dealer. We did a DPS 3, we did a DPS 67, we went through, we did all the paperwork, we sent everything in. I own it. I have a copy of a letter from the state, from the Commissioner Bradford, saying that these are fine. And it's good, no problem. I bought it that way. The only problem is people are getting arrested right now. And this has started happening primarily since the election. We're seeing a much greater push on enforcement. What was said at the meeting was this: we understand that there are many guns out there built during the gray period. Gray period, their words, what that means is during a time period when the Connecticut State Police had issued a letter saying that all firearms built prior to October 13, 1994 were pre-bans. So the state police is saying, we know these are out there, but we no longer accept that interpretation. And therefore, while, at least according to the state police the other day, this was Brian Fawnin, Trooper Fawnin, said, while we're aware of it, and we're not going to go looking for these guns, at least that's what he said, if we find them, at a minimum, they're going to be confiscated. Now, that minimum is just that. Andy and I are currently handling active cases where owners of these firearms have been arrested and charged with felonies. So, as you sit here today, many of you have certainly purchased firearms from your dealers, which at the moment, the state police, if they're on this list of 56, may deem to be a felony. If they find you out there, you're out at the range, they walk up to you. At a minimum, they may seize them. If you're unfortunate, you may be charged. We've just resolved one of these cases involving a MAC 90. And the MAC 90 was one of the guns that the state police last Wednesday referred to as an example of a firearm which they consider to be an assault weapon. So let's take a step backwards here. Why is that? The reason is this. Remember when we talked about AK-47 type? Their position right now is that an AK-47 type is a specified gun on the 93 Act, and therefore it is never a pre-ban. And accordingly, if you have it, they consider it to be a felony. Okay. A second issue that we're seeing here on this as well, on legally purchased from dealers. And we're going to come into some of the responses, and I'm not sure how effectively they're going to be able to prosecute these cases, and I'll tell you why. This is not fun. I don't mean to scare anybody, but it is, as I speak right now, we are defending clients who are charged with felonies. It's outrageous. However, second issue here. We've recently had a client who purchased 10-round magazines from his dealer. These 10-round magazines have got a block built into them so that the follower will only go down far enough in order to load 10 rounds. The state police position was, well, somebody could go into their machine shop. They could take some kind of a mill or maybe some kind of a hand drill. They could drill out the pins that hold the block in there, take the block out, and then you could load more than 10 rounds. That describes many 10-round magazines. But their position, and they did charge both of them as felonies, was if we decide it's not permanent enough, what does that mean? I have no clue. Once again, a lot of this is going to have to get sorted out in the courts. But be aware of the fact the issues are out here. Okay. So let's, once again here, what is an AK type? Back in 1993, I had hair in those days, by the way. Maybe sees pictures of me back then. I was skinnier, too. But back in 1993, we came into the court and we said, we have no idea what an AK type is. And while the court sustained it, the state police at the time, what they said to us and to all of the dealers that I'm aware of, is that an AK type is a firearm that shoots .762 by .39 caliber and has other characteristics of a AK-47, which is a machine gun. It's not even a semi-automatic rifle like you would see here in the civilian world. But for years now, it has always been their position that if it's not in .762 by .39, it is not an AK type. Their new position, at least as stated to us last Wednesday, is they do not care what caliber it is in. If it has any common parts with an AK, whatever that might be. I work for a defense contractor. I mean, I know what an AK is. It's not this. But what they're saying is, well, if it shares common parts with things that aren't an AK-47, but which we think looks like an AK-47, you may be charged with a felony. We go back to due process. If I can't understand what it is, I mean, the legislature, I'm sure Craig will tell you that most of the Democrats in the legislature will tell you very clearly that I'm not a man of common intelligence, but I think all of you are, and none of you have been able to tell me what it means yet. So we have a problem here, and it's a big problem because thousands and thousands of these have been sold in Connecticut, and I have no idea what they intend to do about it. But we will be in court this week on one of these cases. Okay. Now, As all of you are sitting here right now, one of the questions you're probably asking is, remember I started this presentation with, "You must be kidding"? All right, well, part of the question now is, what do we do? How are we going to deal with this very, very aggressive interpretation, which we're seeing right now, until we can get this resolved through the courts? And what we were told by the state police, which is technically known now as the DSPP, was that if you have a firearm and you want to know whether or not it is banned as an assault weapon, you can call the Special Licensing Firearms Unit, SLFU, ask for a detective, bring it down there, and they will tell you whether or not it's an assault weapon. Of course, if they decide it is, they're going to keep it. Right, but, well, what they have said is if people come down voluntarily, they're not going to arrest you, they'll just seize your firearm. Okay, so now we have a person who's not an attorney making a determination on a law that some of the finest minds here in Connecticut have no idea what it means. However, I put it out. That is what they've suggested. The other alternative, and the one that we see relatively commonly, is get in touch with your counsel. While we can't answer every question, there are many firearms that we can speak to with a relatively high degree of confidence. So in many cases, if you call down to counsel who are familiar with these laws, they're able to look at it and call you back and say, nope, that one's not on the 56. And there's plenty of things that are not. So sometimes we can give you some peace of mind. If we can't give you some peace of mind, the state police made an offhand comment. I'm not sure what to make of it, but I simply note it because we know in the past this happened with many. What Trooper Fawnin said is, of course, if the firearm is not in Connecticut, it's not our problem. I understand there are guys driving around in Mercedes in New Hampshire and Pennsylvania because their self-storage units now have grown immensely. So it's driving around with something that's contraband is not something I can recommend, but I simply note that the state police did say in their presentation that if it's not in Connecticut, it's beyond their jurisdiction. So we simply note that. Okay. Now, here's something that everybody, if there's only one thing you remember tonight for everything that I said, it's a statute, Connecticut General Statute 53A-6, reasonable reliance as a defense. And the language is right up here on the screen, so I'm going to give everybody here a minute to read this, and we can get copies of this to people as well. But what this says is that if there's a criminal law in Connecticut and there has been a statement by the regulatory agency responsible for enforcing that law, and you rely upon that you cannot be prosecuted for a violation of that law. So once again here, just to read through this, unless such mistaken belief is founded upon an official statement of law or an interpretation of the statute or laws relating to the offense, officially made or issued by a public servant, agency, or body legally charged or empowered with the responsibility or privilege of administering, enforcing, or interpreting such statute or law. Well, what might we have that might look kind of like that? Okay. And here's the famous letter from Dave Clough. Many of you have probably seen them. It's been up on the CCDL website for many years. But Dave, back in 2013, when the latest assault weapons ban came through, wrote over to Commissioner Bradford, Commissioner of the Connecticut State Police, the people responsible for enforcing this law, and said, what about guns prior to October 13, 1994? And the commissioner writes back and says in the letter, Section 11 of Public Act 13-220, which was the amendment to the original Assault Weapons Act in 2013, was intended to resolve an ambiguity in Public Act 13-3, the original Act, 2013. The section clarifies that it is the intent of the legislature to exclude assault weapons manufactured before September 13, 1994 from transfer restrictions and registration requirements. Well, that seems pretty clear that the state police, the body who is statutorily enforcing this law, has said that if your gun is built prior to that date, you don't have to register it, and it's not restricted. Now, whether he was right or whether he was wrong doesn't really matter to you. What matters to you is that if you relied upon that, and I think a very large percentage of the dealers in this state did rely on that letter, they've sold them out there. You as, CCDL members, by definition, this is, a tremendously responsible group. And as you looked at it, and you came through, and you looked through, and you read this letter, and you spoke with your dealer, and you tried to do everything right, if you have one of these firearms, and you bought it in reliance upon it, should you be charged? The first thing your counsel's probably going to say to a prosecutor is, here's a copy of the Bradford letter, and here's reasonable reliance. It's a defense. It's not going to stop them from arresting you. An arrest is not fun. It may not stop them from seizing all kinds of firearms you have. You're going to be handcuffed. You're going to be processed. This is not something you want to happen. But if it does, and you're talking with your counsel, who may not be familiar with this, if you've got, a personal attorney who hasn't done a lot of this, one of those questions you're going to ask is, what about 53A-6, and have a copy of this? So for everybody in that position, I think you probably, and we can get copies of this distributed out here, I think you probably want to have a copy of that letter, and you want to have a copy of my little quote here from 53A-6. Okay. So once again, just kind of to recap, you have one of these firearms. If you're in this position right now, get these letters, get other things, speak with your counsel, be proactive on it. I have seen cases where an officer came in and looked at a firearm, typically at ranges, looked at a firearm and said, I think that may be an assault weapon. And the owner has been able to pull out some paperwork and say, listen, here's paperwork where I bought it. I bought it from a dealer. Everything was legal. Here's a copy of the letter from the commissioner. Here's 53-6. I've spoken with my attorney. And we're waiting for resolution on this. But, to the best of our knowledge, it's legal. Officer may exercise discretion and you may not be arrested. That would be a very good thing. If they decide to seize your firearm, do not resist by force. We'll sort this thing out in the courts. Officer says, I'm taking it. He's going to take it. And, as I say, when it gets to court, we'll sort those out. All right. Here's another one. Anybody in this room an FFL? Got a couple. Yeah. So, all right. FFLs. This is going to start happening. People are going to be coming back to you in the current environment, and they're going to say, listen, I bought this gun from you last year. I want to sell it back to you. I paid you $1,000 for it. I only want $200 for it. I just want it out of my name. Will you take it back? If it is one of these 56 specified guns plus type and whatever else that means, but if it may be on there, it's not a pre-ban under their current interpretation. Whether right or wrong, that's their interpretation. And as a dealer, if you buy it back, you're going to be charged 1 count felony for transfer and another count felony for possession. This was absolutely categorically clear from Trooper Fawnin the other day. So to anybody who's a dealer, or if you go into your dealer and say, hey, I want to sell this thing back to you, if it comes under this list of 56, where it is not, the dealer cannot buy that back. That is not an option that is open. Okay. Yes. And that's all I'll say. Right. All right. Once again, all right, the key date for whether something is pre-ban or not pre-ban. There's lots of guns that are not on this list, clearly not on this list. October 13 of 1994, manufactured, not when you bought it, but when it was built. Oh, my apologies here. We got a typo in here. And September 13, 1994. So we're going to, I figured we'd get one typo in here before we got to the end. So so under PA 13-220, if it was exempt in 1994, it remains exempt. If it would have had to have been registered in 1994, it's an assault weapon. It cannot be pre-ban. All right, let's go to the next one here. Now, as we go around the room right now, I look at all your faces and it's like, I don't get it. How can I possibly understand this? And remember when we started right here and we talked about due process? That a law which is not stated with specificity, where a person of common intelligence understands what is banned, that violates due process. This is a defense. And if you are charged, one of the things, the second thing you're going to come in is say, hey, I don't know what this says. I will tell you that I have police officers within the last month who have arrested people who came in after the fact when we went and we met with them and said, counselor, the first thing we're going to tell you, I have no idea what this law says, and I haven't a clue. This is common, and given that situation, where there's a finding that a person of common intelligence would not have understood this, it is void for vagueness. Such a law cannot be enforced. Okay, let's go over to the final one. What about the Second Amendment? We all the time here we talk about the Second Amendment. We're a pro-Second Amendment organization. We lost Benjamin versus Bailey. We lost Shue versus Malloy. When people have come in, it's like, we won Heller. Great. Some of my old partners, wrote the amicus. But there's a change coming right now, and that change is happening with the change in the composition of the board. We got Brett Kavanaugh. We got Neil Gorsuch. We are looking at a time period where it is reasonable to expect that we are going to see an interpretation of the Second Amendment, which is going to tell states that these laws that they've passed on assault weapons are no longer enforceable. So we'll come over here and take our last slide here. Yep. All right. So real quick, I want to go through a summary and then I'm going to drop down into questions here. Number one, if you have a firearm and you're unsure whether or not it's legal in Connecticut, you need to speak to counsel. Or if you choose to take it to the state police for determination, you must call them beforehand to arrange with a detective. 2, document your guns. Before you have that knock on the door or an officer saying, when was this thing built? Put together your documentation. Keep it with your firearms. You're out there at the range, someone comes up, have that slip right there showing that when this gun was built. You need to know what you have, when it was built, and ideally what I like to see is take a picture of the side plate of every firearm that might be an issue. What we've sometimes seen is they come and they seize the firearms, and until we get into court, what was it? Well, I don't know. It was black. That's helpful. Yeah, it's seen some of those. Where clients have pictures of the side of the receiver and the actual markings, it's very helpful to us. So it's just one of those things you can do to make our job, and don't let them get stolen. They get stolen, they get recovered, and then it gets messy in the system. So don't go there. Okay. As far as, we've talked about ranges, things of that sort. Don't look for trouble if you have something that may be trouble. What was said last Wednesday is we're not going to go looking for these. I don't know whether I believe him or not. But he said we're not going to go looking for them. But if we see him, he's a police officer. He's got a duty. I mean, that's what the police are supposed to do. So if they see a crime being committed, they're going to enforce the law. Don't put them in that position. So be a little careful about, where you're out with things if there's a question. Social media. Social media, pictures of guns, especially with minors, has become a disaster. It's, once again, it's outrageous. Under the First Amendment, it is greatly troubling. However, recent case, firearms owner, his younger brother wanted a picture of himself with the firearm. They took a picture. There's no magazine in it. It's pointed in a safe direction. It's nothing improper about it. He's handling it properly. Posted it on Facebook. Somebody at school saw it. The police were notified that this individual has a firearm. There's somebody living in town and he's got a gun. Yeah, imagine that. And what happens next? The police officer goes out and applies for a search warrant. That based upon the picture, they believe it's a machine gun. Why? No reason given. But the judge issued the arrest warrant. They went in, they seized it, they seized everything else, and things didn't get better from there. Don't put yourself into a situation. Be very, very careful with the school system. We have seen suspensions at the school system for the most innocuous of comments about firearms. It's another one of these issues that eventually has got to go up to the high court, and we're going to have to take a look at. But for right now, be careful. And finally here, hold on. Kavanaugh's coming. So soon, I'm fairly confident we'll see some better days here. With that, I'd like to turn this over to question and answers and call my panel on up here, and we'll take it from there. Gentlemen, please come on up. Doug Dubitsky, Andrew Buzzi, and Craig Fishbein. Thank you, gentlemen, and to our representatives, thank you for your service.
I just have one quick comment that I didn't see anywhere in the presentation. Everybody needs to look very carefully, not just at this list of 56 guns, but 53A202, 53A202 yes. Has 53202A. I put the A in the wrong place. Right. Has 4 different sections. The top section, subsection 1A, has this list of 56. But there are 3 other sections that list firearms. The definition of assault weapon in Connecticut encompasses all of them. So you may well have a firearm that is not on this list of 56 that is in the first section. You may have one in one of the other sections. There are several hundred firearms listed total. Some of them say the word type near them. Some of them do not. In one instance, there's even there is a section that deals with semi-automatic rifles, which actually has at least one firearm on it that is a pump action. do not be lulled into thinking that if you have a Remington 7615, that you're safe because it's a pump action. It's on the list of banned rifles. It is considered, under Connecticut law, an assault weapon, even though it's not even semi-automatic. The way these firearms were chosen would make you laugh or cry. There is no rhyme or reason to them, and you may well have one and not even know it. So when you're trying to figure out if you have an assault weapon, it's not limited to this little list of 56. Look at the statute. Check to see if yours is on that list. The other thing with regard to manufacture date, we're talking about the manufacture of the receiver or whatever part has the serial number. So with an AR, you're talking just about the receiver. When was that receiver manufactured? There's all kinds of little parts that snap on and off, barrels, shrouds, grips, all types of stuff that are replaceable. They're not talking about the day you assembled it. They're talking about the day that receiver was manufactured, the day it was stamped with the serial number. That's the day that you need to document, not the day that it was put together.
And just to clarify that, the list of 56 is whether or not it's pre-ban. The additional list applies to all guns made after that key date. So if it's made prior to that date, you would look at the 56. If it's made after that date to determine whether it's an assault weapon, Doug's absolutely correct. You'd have to look at the entire list.
53, 202, small a. So there's a dash, 53-202, small a.
Yes.
Here, let me just talk for a second.
Sure.
I just wanted to make a couple of comments before we get into the question and answer. I think you all understand, based on Greg's very comprehensive presentation, that this is complicated. This is very, very complicated. So the first rule that you need to know is that if you are involved in an issue that has to do with firearms, you need to have someone who's helping you who actually knows firearms. There are lots of attorneys in Connecticut. There are lots of very good attorneys in Connecticut, but there are very few attorneys that actually know about the firearms. And the first question that we have to deal with is whether it's on this list. And I can tell you, the state police has a lot of trouble figuring out what's actually supposed to be on this list. And I've had good conversations with members of the state police about, hey, this is not on the list because of this. And it all comes to the fact that, and I'll tell you why I love this organization. We all share history, knowledge, and passion of the Constitution and our right to own these firearms. We've grown up with it. It's part of who we are. And this organization channels that passion into effective means where we can protect and preserve our rights. We talk to our legislators. We talk to the governor. We talk to the people who make the laws. We help them. We help Mr. Dubitsky. We help them all, okay? That is very, very important. But it is not that when you are dealing with a law enforcement issue, that is not the time for that passion to come out. I deal with the cases after the people get arrested, or in this state, we have a law, 29-38C. It's the risk warrant law, okay? I remember when it was proposed, and I fought very hard against its passage. And I've read through all the legislative history, and there was a very intense fight in the Assembly about that. But 2938C allows the police to come into your home and to seize your firearms. Okay, they can get a warrant for that. But the the standard by which they can enter your home and do that is lower than what you would have to prove under a regular probable cause warrant for a criminal action, because they only need the standard is if they feel that you are a risk to yourself or a risk to someone else and that you have firearms, and then they can come in. So I deal with a lot of cases where people's firearms have been seized under that law. And under that law, those people have committed no crimes. Most of the time, they've committed no crimes whatsoever, okay? So what I'm going to tell you is this. You spend a lot of time with this organization trying to protect, preserve, restore your rights, okay? Now I'm going to ask you to do something. I'm going to ask you to exercise your rights. And when I say exercise your rights, you got to understand that you have some rights too. So that when you are being questioned about your firearms in a situation, you may want to say to the police officer that you would be happy to cooperate them through your counsel. Many of the troopers that I deal with are extremely professional people. And if they're investigating a matter, they will start asking questions. And if you feel that those questions may be invasive, you have a right to have counsel before you ask them, before you answer them. And you may want to do that because a lot of times when I'm dealing with these issues, I'm unraveling statements that were made during conversations prior to a seizure. Statements which ended up leading to a seizure, okay, that otherwise would be innocuous, kind of like what Greg said about posting photos on Instagram and being careful with Facebook. So you want to be very careful about your interactions. It's important. And the second thing you want to do is you want to understand that you have a right to be secure in your property. So a police officer knows that when they ask you, may I enter your home? If you say yes, then he doesn't need a warrant because you've invited him into your home. I'd like to see your firearms. You say yes. Why? Because firearms owners are amongst the most law-abiding people in this country. Okay? They respect the police. They want to work with the police. And I love that about who we are. But we have to understand under these circumstances. And I have had a case where I had a guy who was just like you. He did zero wrong in his life. Okay? He was a very decent person. He had a bad day. He wrote a text to his ex-fiancée that you would consider relatively innocuous, but it was taken as if maybe he thought about he was going to hurt himself. And the police came to his house to check to see if he was okay. And what was the guy doing? He was gardening. He was gardening in the front of his house. Police officer shows up, says, "Hey, how you feeling?" He says, "I'm all right." Said, "I haven't had the greatest day," because him and his fiancée had broken up that day. But he said, "It's not had the greatest day." And he said, "Well, what about this text?" And the text just had something to do with the fact that he had life insurance for his girlfriend and his daughter. Okay? And he said, "Yeah, I do. I have life insurance for my girlfriend and daughter." I said, "Are you thinking like you're going to hurt yourself?" No, not like that. He was a little surprised. Okay? He says, "Do you have firearms?" I said, "Yeah," because police officer asked him a question. Police officer asked him a question. He's a law-abiding person. He's going to answer the question, and he's going to answer it truthfully. And he did. He had firearms. Officer says, "You know I'm going to have to take those." You know I'm going to have to take those. He's just a normal, law-abiding guy. Police officer just told him that he's going to have to take his firearms. So he said, "Okay," because he did. And without cause, without a warrant, he let him into his house. He took his firearms. And when he took his firearms, there were certain items in there that were questionable under that list. Okay. And that took 2 years to get resolved, and 2 hearings, and a lot of time and effort. Okay. So you have some rights. You still have a few rights left here. Okay. So use them, because if you call me, or you call Greg, or you call Craig, you call one of us, and you say, hey, I'm getting these questions. Can you talk to, this officer left his card. They do that a lot. Here, have him call me. Can you do it? Then maybe we can resolve it. And it's much better that way. And it's much easier. And it's much less expensive than having to go through first the hearing under the 2938C. You get a hearing within 2 weeks. If you apply for one, you got to go through that hearing. If the judge decides that he can hold your firearms, which he can, and he can hold them for up to 1 year, but that's all. After that, they have to be released. Doesn't matter why. That's the only statutory authority that he has. But then if they look at it afterwards and they think that there are questions, magazine questions like, is it really a limited capacity magazine? It looks big. Okay, or is it really one of the firearms on this list, which, let me tell you, is a very complicated procedure in determining whether they are or they aren't. These are the types of things that end up into arrests and then further hearings and further cost and resolution of charges and things like that, which we want to avoid. So I think it's admirable. I think it's important. I think it's necessary for everyone in this room who lives and loves to live in this state to be involved in our political process, to respect the process, be involved in it, and get our legislators to change some of these laws. But in the meantime, exercise the rights that you have to try to keep yourself out of the problems that we're having in simply the interpretation and enforcement of these laws.
I think we got some questions over here.
Yes, sir.
In the case you just mentioned, the guy that was gardening, and the cop says, we're going to have to take your guns. At that point, if I'm gardening or anyone else in this room is gardening, what do we say?
You say, and I tell this to everybody because, I'm an instructor too, and I teach, and I say, look, you say to the officer, you say, officer, I respect you, and I would like to be able to cooperate with you with the advice of my counsel. Here's my lawyer. Or I'll have my lawyer get in touch with you if you don't have one at that time. And most of the time, the officer will be respectful of that. Matter of fact, I shouldn't say most of the time, because I have never met a trooper or a local police officer that hasn't been. I haven't had that experience. Okay? They will usually back off and do whatever they got to do. But when they come to your door, if they have a warrant, you cooperate. That's what you do. If they say, well, I think I have cause to do it, you still cooperate, because we will sort this out. But you want to be careful about what you do.
You don't want to give up your rights and just say, come on in.
When you say that,
they don't need a warrant.
Then they don't need a warrant. Then you don't have any cause to challenge any warrant that they would get, or that search, not the warrant that they would get after, but the search. If they get a warrant, then they get a warrant. That's all there is to it. If they get a warrant, that means they have the legal right to enter. Okay? Then we deal with that, the issues surrounding the issuance of that warrant. Yes, sir.
You rescind that, you say, come on in, and he's in the house, you say, look, I changed my mind. You're not welcome here, please leave.
It's very complicated. That's very complicated. And what happens in the hearings, because the gentleman that I was just talking about, after all of that occurred, they did hold the hearing on the firearms, and he decided that he would go to the hearing and he would just explain it to everybody as to what was going on, and he didn't bring a lawyer with him. And I read the transcript, and in that transcript, both the judge and the state's attorney asked him, said, really, we'll give you We will give you time to get a lawyer. Why don't we put the hearing off? And he decided to proceed, which is why it made the case very, very complicated afterwards. I came in after that. Okay. So you really want to have representation in this area. It's really very important. Did I answer?
I don't understand it. You say, yes, I do have firearms. You say, I'm going to confiscate them. At that point, and you say, no, you can't confiscate them. You're not welcome here.
Well, at that point, you can say, you can't enter my house. You can say, look, I think you ought to talk to my lawyer. You be polite. Always be polite.
Yes, I know. But the idea is, after you said yes, you can then say no.
Well, in that scenario, you said, yes, I have firearms. You didn't say I could come into my house. The next question, even though the way the next question was phrased didn't sound like a question. See, that's the point. It didn't sound like a question. Because he said, you know I'm going to have to take your firearms. That's what he said. You know I'm going to have to take your firearms. And I have that. I got that from the transcript of the hearing because the officer was there and he testified. And, of course, my client had testified about it too. And they both agreed that the officer phrased it in that way. He didn't say, can I come in? He said, you know I'm going to have to take your firearms. And because he said it that way, my client immediately didn't think that he had a choice. He didn't think he had a choice at that point.
I mean, to the extent that an officer has come into your home, number one, you have a right to remain silent. Most officers would recommend that you do so. You don't really want to have a long conversation. It's not the time to do it. Officers are going to respect your right to maintain your silence. So that's number one. Number two, it would be perfectly reasonable after they walked in to say, officer, just a question, do you have a warrant to be in here? If the officer says no, and you say at that point, if you don't have a warrant, I'd really like to have you speak to my counsel, before we go any further with this. I think Andy's right. Most troopers at that point would say, okay, who's your counsel? They'll pick up a telephone. They'll call. I hate when they call at 3 o'clock in the morning, but it's happened. So,
all right, out of respect for the time here, do you want to, as far as the warrants go, do you want to talk about broaden it up back to some of the other subject matter? Just does
Sure.
Craig or Doug or Andy?
Yeah,
Or,
I know somebody in this room is thinking, why do I want to deal with this bullshit? I'm just going to get rid of my guns, Somebody in this room is thinking that. That's what they want you to think. This is all about control. So, that's at the root of this. They make the rules very complicated. We can't figure them all out, quite frankly. That's what they want to have happen. I just wanted to just bring up a few of the other things. The statute on pistol permits presently says that if you're arrested for any crime that, if convicted, would make you an ineligible person, your permit shall be revoked. Not suspended, revoked. So that's felony or one of the 11 misdemeanors. So just know that. The other thing is, with this electronic thing that we're going through and, Big Brother and all this stuff, databases from other states are getting updated. I just had a call yesterday from a gentleman who was convicted in like 63 of aggravated assault. And in Maine, it's a felony. And he's had a pistol permit since like 68. But the state police said, nope, no pistol permit. You can't have any guns. This guy's got like 40 guns, So just be wary of that. The police don't always know the law. I just had a case where at-risk warrant out of Massachusetts, and the girl checked herself in. She actually signed the DPS-3 forms to her father before she checked herself in. And then father called the state police to get approval on the transfers because you got to get approval. And they said, no, you can't do that because she's an ineligible person because she's checked into a mental hospital. You got to turn in all those guns. And they're threatening. We're going to come and take those guns, and everybody in the house is going to get arrested, is what they said. And I called and I said, bullshit, what law says that? And set them straight on the law. So, just because it's the police doesn't, we're not looking for civil rebellion, but they don't always know the law. So Thank you for listening.